Hello, everyone. Welcome to the NIJC's second virtual Pride Asylum training. My name is Anisha Gandhi, and I'm the managing attorney for NIJC's LGBT Immigrant Rights Initiative. We really appreciate everyone taking the time to learn more about NIJC's work and how you can help by representing an asylum seeker. This training will be geared towards LGBT asylum cases, but will cover basics of asylum law generally as well. And this is part one of two trainings. So the second training will be on Thursday, this Thursday, June 17th at 2 p.m. Central Time. And with me today are some of my amazing colleagues at NIJC's LGBT Immigrant Rights Initiative. Most of us do help advise pro bonos on their LGBT immigration cases with NIJC. Before we begin, on the substantive part, I just wanted to say a little bit about NIJC. NIJC is a legal services provider based in Chicago, but we have offices in Indiana, DC, San Diego, and we serve about 10,000 non-citizens each year. And we do this work primarily through our networks of pro bonos, like you all who are participating here today. What makes us unique among the immigration legal service providers is that we do both high volume direct representation and also high volume impact litigation, policy, and advocacy work. We believe that it is very critical to our mission and to the work that we do by leveraging and being informed by the experiences of our clients that we represent and work with to inform our policy, education, and litigation goals. And your representation is crucial to the success of asylum seekers. Non-citizens in removal proceedings do not have the right to appointed counsel, but when they do, they're 5 times more likely to obtain relief. And as you all will see today, asylum law can be incredibly complex and both procedurally and just legally the law. And it has become even more complex procedurally, specifically in the past few years. And it is hard to believe how a pro se individual can be successful on an asylum case given the number of barriers. So your representation really does make a difference in the life of an asylum seeker. We also have a number of other pro bono programs at NIJC. We offer opportunities to represent individuals who are seeking U.S. citizenship, for asylees and refugees petitioning for family members or to become a lawful permanent resident, children seeking special immigrant juvenile status, and survivors of domestic violence and other violent crimes who are eligible for VAWA or U visas. And so if you have any questions about our interest in any of those other opportunities, you can feel free to check out our website, or you can reach out to me after the presentation. My contact information will be on the last slide. And just briefly going to mention how clients come to us and what resources we have for pro bonos to ensure success on your case. So we receive referrals through our different offices in different parts of the country, detention hotlines that are run by our detention and LGBT teams, community and social service organizations, our help desk at the immigration court, and often just through word of mouth. We conduct an in-depth legal screening when somebody comes to us seeking our representation to determine eligibility and whether they meet our income criteria. And if we accept the case for representation, we sign a retainer and we start looking to place that case with pro bono. So that means that even if we can't find pro bono representation, we still are going to represent that individual moving forward. So once the case is placed with an attorney or a team of attorneys, NIJC remains of counsel and is with you every step of the way. So while you will be the one to go to court, to be in contact with the client, to prepare the case, we will still be there to provide document review, technical assistance, and for LGBT cases, we also keep up-to-date country condition materials that you can then tailor to your case. So our agenda today, we're going to do a little bit of an LGBT 101, and then move to the basics of asylum law and break down the elements of asylum. And then on Thursday, we will do a more in-depth look at preparing and presenting your asylum case. So before I turn it over to my colleague Beck, I'm just going to do quickly a few housekeeping matters. As you will see on the right-hand side, under I think, handouts. You'll see that there are 4 handouts. You can download these today, and they include our agenda, a copy of today's PowerPoint, and our Asylum manual that you can also find on our website. And so feel free to download these materials. You can also find all of them on our website as well. And you know, as you will see, like we'll be referencing the Asylum manual multiple times. It goes in depth, so everything that we're covering today is also in the manual, and so you don't have to take too many notes today if you prefer. And then also on the right side, you'll see where you can ask questions, and please feel free to ask questions. If we have time at the end, we may go through them on the webinar, but we'll be messaging you back with responses to those. And please do use the questions box, not the chat box. And then lastly, the CLEs, we will be emailing you certificates for CLE. And if you have any questions regarding CLE, like you can just feel free to reach out to me. Again, my contact information will be on the next slide, or on the last slide, excuse me. And with that, I will turn it over to Beck.
Thanks, Anisha. My name is Beck Earl. I am a paralegal on the LGBT team here at NIJC, and I use they or she pronouns. Today, I'll be going over some terminology that the LGBT community uses that will be important while representing LGBT individuals. Next slide, please. The topics I'll be discussing today might seem basic, but the ways in which we talk to our clients are very important. They impact the client directly and can be a way to form or break trust with them. Everyone deserves respect, no matter if they're LGBT or not. More so than in many other cases, the words that you use to speak to your client and about the case will affect their willingness to open up and to trust you. It's important to keep in mind that your client may also have a claim of persecution that involves being bullied and called derogatory names, so it's important for you to be sensitive as to the words that you use. So what does LGBTQ stand for? The L refers to lesbian, meaning attraction between women, or in some cases, genderqueer or non-binary folks assigned female at birth who are also attracted to women. Gay refers to attraction between men. Sometimes the word gay may also be used in casual context by LGBTQ people across the spectrum as an umbrella term for all LGBTQ people. Bisexual refers to folks who are attracted to people of multiple genders. Transgender refers to folks whose gender identity differs from the sex they were assigned at birth. And lastly, queer is an umbrella term used to refer to folks across the LGBTQ spectrum. Next slide, please. These are some examples of terms that you may encounter while representing folks in the LGBT community. Intersex refers to a condition in which an individual is born with a reproductive or sexual anatomy or chromosome pattern that does not fit typical definitions of male or female. You should never use the word hermaphrodite when referring to people who are intersex. Genderqueer refers to a person who does not subscribe to conventional gender distinctions and may use a variety of pronouns. Non-binary refers to a person whose gender identity falls outside of the male-female binary. Some genderqueer people, for example, also identify as being non-binary. Aromantic refers to a person who does not experience romantic attraction. Asexual refers to a person who does not experience sexual attraction. Pansexual refers to a person who experiences attraction to all genders. A note on pansexuality and bisexuality. These are distinct identities, although they sound similar. Many people who choose to self-identify with bisexuality use that term because they experience attraction to people of different genders in different ways. Two-spirit is a modern umbrella term used by some Native American folks to refer to people of varying sexual identities who fulfill a third gender role in their community. And lastly, the last example we have here is polyamorous, which refers to a person who experiences attraction and intimate relationships with more than one partner. Next slide, please. Can I have the next slide, please? Okay, thank you. So then on this next slide, we just have some pointers about familiarizing yourself with appropriate terminology. Firstly, it's important to be aware of what these terms mean. Avoid terms that may be disrespectful, put another person down, or make them feel bad. Allow individual self-determination in their use of identity terminology. We'll also talk more about that in part 2 of this training later this week. When confronted with a term that you don't know, react with genuine interest and respect as to its meaning. And lastly, mistakes happen, and it's okay if they happen. You can apologize, learn from that mistake, and move forward. We'll also be sharing some resources that you can use to learn more about the terminology that you'll encounter. Next slide, please. In this slide, we'll go over some ideas that you'll encounter in LGBT cases that are related to the examples that we shared earlier. Sex is the classification of people as male or female or as intersex. At birth, infants are assigned a sex, usually based on the appearance of their external anatomy. This is what is usually written on the birth certificate. However, a person's sex is actually a combination of bodily characteristics including chromosomes, hormones, internal and external reproductive organs, as well as secondary sex characteristics. The next term on this slide is sexual orientation, which is an umbrella term that describes a romantic or physical attraction to others. Homosexual and homosexuality are words that are used to describe individuals attracted to others of the same sex. It's important to note that although this is the term that the court is most likely to use to discuss your client's case, it's often considered clinical and slightly derogatory, so you should avoid using it in your own brief as well as in conversation with the client. Some alternatives for this would be lesbian or gay. The next term on here is gender. Gender is a social construct which is usually expressed in binary terms of woman and man. Gender identity is the gender that one knows themselves to be. For trans people, gender identity often does not align with the gender they are assigned at birth. Some trans identities include trans woman, trans man, genderqueer, gender fluid, meaning a person whose gender identity is not fixed, bigender, meaning a person who may identify and express their gender through various genders. There are also culturally specific terms, such as two-spirit, which should not be used by people outside of those communities. There isn't just one way to transition. Not all trans identity or experience looks the same. The last term on this slide is gender expression, which refers to how a person expresses their gender identity through self-expression, actions, behavior, dress, makeup, hairstyles, or other ways. You might not know someone's gender identity just based off of their gender expression. While gender identity is inward, gender expression is outward. Sometimes the two do not match, especially in situations where external expression of gender nonconformance could pose a risk to safety. It's also important to note that gender identity and sexual orientation are distinct. Trans people can identify as any sexual orientation. Some trans people may go through a period of identifying with one type of sexual orientation before coming to terms with their trans identity. Others do not. Lastly, up here in the corner, there are also some common acronyms that you may come across. Sexual orientation and gender identity is often shortened to SOGI, and gender nonconforming is often shortened to GNC. Next slide, please. On this slide, we have the Gender Unicorn, which is a great resource developed by TSER, Trans Student Educational Resources. You can see that gender identity, gender expression, sex, physical attraction, and emotional attraction exist on a spectrum. It's important to be flexible and open to changes that people may have regarding their sexual orientation and gender identity. Some clients understand their sexual orientation or gender identity more fluidly or more rigidly than others. It's important to understand that some clients may feel that they were born gay, and others will not come to understand that they are LGBT until they're adults. Some clients will also come out as transgender after we have begun working with them. So it's good to give them space to be open with you if their feelings about their gender or sexual orientation change over time. Some clients may still be figuring out exactly how they identify, and some may not be very familiar with a lot of these identity terms, especially if they're coming from a background of being isolated from other LGBT folks. Next slide, please. One of the last points that I'm going to touch on are pronouns. Gender pronouns specifically refer to people you're talking about. If you're asking someone what their pronouns are, we suggest introducing yourself and your own pronouns, and then asking the client about their pronouns. For example, I could say, "My name is Beck. I use they or she pronouns. What about you?" The pronouns on this slide include pronouns from the gender binary, as well as gender-neutral pronouns. We'll talk more during part 2 about how to work with your LGBT client, but for now, we wanted to ensure that everyone was familiar with the vocabulary. Next slide, please. These are some useful resources that you can use throughout the duration of your LGBT case. I also want to just mention that in part 2, we'll include more in-depth practice pointers on working with LGBT asylum seekers. And with that, I will pass it over to Lee.
Thanks, Beck. Hello, everyone. My name is Lee Vanderlinden. I use they, them pronouns, and I'm a supervising attorney on the team. So now we're just going to go through some of the basics of asylum law, a little bit procedurally, a little bit legally, substantively. This is, again, just meant to be an overview. Like Anisha mentioned, we'll have plenty of resources for you, including some of that are attached as some of the materials in this presentation. So this training focuses on representing individuals who are seeking asylum, withholding of removal, or protection under CAT, which is Convention Against Torture. Before I dig in, we're going to start by taking a quick poll just to see who is with us in the audience. So if we can start that poll, please. As you can see, the poll reads, have you ever worked on an asylum case before? And select the one that's true for you. Yes, only affirmative cases with the asylum office. Yes, only defensive cases with immigration court. Both or neither, no. So I'll give you a couple of seconds to pick the option that is based on your experience level, and please do participate in our poll. Okay, and I am seeing some of the results come in. It looks like the majority of us have not yet worked on an asylum case, which is great. We're so glad that you're here and learning with us. We see some people only have affirmative cases. About 16% of us have done both, and a smaller percent of us have only done defensive cases. So we can exit out of the poll and move on to our next slide, please. Great. So here we see a little, somewhat of a graphic about what is involved, the types of people involved in asylum cases. So we'll follow the circle around. On the top left, we see the Department of Justice, and those are the defensive cases. So EOR is immigration court. So we have both the local immigration courts and the BIA, which is the Board of Immigration Appeals. And dissimilar to other types of courts, there's just one BIA. So if you are working with a client with a defensive application, that's the quarter of the pie that your case will be in. If we move over to the upper right, we have the Department of Homeland Security. In there's quite a few different entities that we would interact with. One is USCIS, and you see in the parentheses AO, that stands for the Asylum Office. So that's where our affirmative asylum cases will be. We also have ICE, Immigration and Customs Enforcement, that has OCC, the Office of Chief Counsel, which are, you can think of as the immigration prosecutors, and ERO, which you might more readily think of when you think about ICE, the Enforcement and Removal Operations. We also have CBP, who are more at the airports and the borders. If we move down to bottom right, we have ORR, the Office of Refugee Resettlement. So if you're working with young people with unaccompanied immigrant children, then you might be more working with ORR. That's more common in the Kids Project and other places in NIJC, but definitely a player in the immigration field. And then at the bottom left, we have us. We have us as attorneys and our clients. Next slide, please. Okay, so here is a little bit more digging into the asylum system. Like we talked about before, we have two sides to this. We have the affirmative side and the defensive side. Again, the affirmative side is housed more within USCIS in the asylum office. These are for asylum seekers who are not in deportation proceedings. If they are in deportation proceedings, then you're on the right hand of our screen in a defensive asylum application. So asylum is a benefit that they're seeking as a defense to deportation. And that's when we are in our upper left part of our pie in the Department of Justice, in EOIR, in the Immigration Court. And again, from there, from the Immigration Court, cases can be appealed to the Board of Immigration Appeals, and then from there, cases can go further up in the line to the Court of Appeals that you and your client are located in. Next slide, please. Okay, so don't worry too much about writing down the numbers. Like Anisha said, there's plenty of guidance that you have access to down the line. But just to show, there is the Immigration and Nationality Act, some major sections that we're working with asylum there, and the Code of Federal Regulations, again, citations to the types of places where we'll find the regulations that we use, and then of course, case law. So like I mentioned before, there's one Board of Immigration Appeals. So those decisions are binding for immigration cases across the board. Of course, unless your Court of Appeals, where you are located, has rejected that, ruled against it. And we also, a quick note, in many other areas of law, binding versus persuasive. We're here in Chicago in the 7th Circuit. I see many of the folks here with us today are in other circuits. Sometimes there's favorable case law in the 9th Circuit and other places that we do like to cite to if there's nothing here in the 7th. But again, that would just be persuasive instead of binding. Next slide, please. Okay, so here it is. Here is the asylum definition broken out into 5 different parts. During this training, we will go through each part as part of an overview, but just again, as a broader picture, someone is eligible for asylum if they meet the definition of a refugee. And a refugee is based on international law, the UN protocol relating to the status of refugees. So someone is a refugee if they're outside of their country, of their nationality, and are unable or unwilling to return to or avail themselves of the protection of that country because of persecution or a well-founded fear of persecution on account of race, religion, nationality, membership in a particular social group, or political opinion. So we are going to, again, go through each of these elements individually. And just keep in mind, it is helpful to just keep them individual and to think about your cases as needing to fulfill each of these elements. And at the bottom of the screen, you have the citation to the INA where the definition is found. Next slide, please. So like I said towards the beginning, we're talking about asylum, withholding of removal, and CAT, Convention Against Torture. There could be many reasons why your clients might not be eligible for asylum, and then they might be eligible for withholding of removal instead. So the asylum manual has a ton more information about the bars to asylum, as they're called. So if someone does face a bar to asylum, then consider whether they'll be eligible for withholding of removal. As you can see, we are pretty similar in the elements that are on the earlier slide. You can see the difference of the 10% or 50%. So kind of the levels are a little bit different, but we're still talking about persecution. We still are talking about the ability of the government to protect. We're still talking about this on account of or nexus, and we're still talking about those protected grounds. Okay, next slide, please. And then now to the Convention Against Torture. As you can see that there are two different forms, withholding and deferral. Again, differences between asylum and withholding that talk about persecution, and CAT that talks about torture. Torture is defined by an act which causes severe pain or suffering. Then there's no nexus requirement. So like we're going to talk about a little bit later on, nexus is the connection between a protected ground and the harm, the why this happened. So that is not in place for CAT. And then the difference between the unable and unwilling for the government in asylum withholding, for CAT, you see this term acquiescence. And another, keeping up with case law, there's a lot of different ways that different courts have defined acquiescence. So and kind of keep that in mind, keep that at the forefront. And again, just burden of proof, it's more likely than not. So similar to withholding, it's that imaginary above 50% threshold. Next slide, please. Okay, so we have a little chart here that compares all of the three things that I just spoke about. So we see at the top here for asylum, yes, it's discretionary, which means that someone could meet the definition of a refugee and still not be granted asylum based on the discretion of the adjudicator. So then we see the burden of proof here that could be as low as 10%. The big practical difference between asylum, withholding, and CAT is the extra benefits that an asylee is afforded. An asylee can petition for their family members. They could qualify for student aid. They could travel abroad, and down the line they could become a citizen. Whereas compared to withholding and CAT, while there's no discretion, there's also not the ability to petition for family, travel abroad, become a citizen. So again, we want to apply for all options that someone would be eligible for, but there definitely is a difference in between that relief. And then next slide, please. Okay, and now I am going to pass it over to my colleague, Tanya.
Thanks, Lee, and hi all. My name is Tanya Linares Garcia. I am a senior attorney with our litigation project and also with our LGBT project. And we're going to be talking about breaking down the elements of asylum that Lee was briefly mentioning before. So if we go to our next slide, once again, we have a breakdown of the definition of refugee. Which gives us also a breakdown of all the elements we have to meet, right? We have to show a well-founded fear of persecution by the government or by someone the government is unable or unwilling to control, and that that the persecution be on account of a protected ground. Then we're gonna start going over our first element, the well-founded fear, on our next slide. Oh, right, before we get to that. So we have a couple of case examples. I'm going to read over them quickly now, but just so you know, these are examples that we're going to keep referencing back to, and we have a few polls so that we can gauge your understanding and also to provide any feedback on our presentation today. So the first case example, Aminatu, a lesbian from Guinea who recently arrived at O'Hare and was detained at O'Hare. She comes from Guinea, where same-sex sexual conduct remains illegal, and she helped organize protests against these laws. In one of those protests, police shot into a crowd. Also, police detained and sexually assaulted other protesters. And during one of these protests, the police detained Aminatu and threatened to, quote-unquote, fix her. She managed to escape, but she fears that she will be sexually abused or disappeared. if she is returned to Guinea. The second case then is Reina, a 25-year-old transgender woman from Honduras who has been living in the U.S. since she was a teenager. As a child, she was beaten by her parents almost daily for quote unquote acting as a girl, but also her parents beat her and her other siblings for minor infractions. Reina never reported the abuse to the police, and now that she's older, there have been some legislative reforms and a task force seeking to curb homophobic violence in Honduras. So these are the cases that we're going to be talking about. Of course, we try to capture a lot of the common fact patterns that we see in our clients. So we can go to the next slide. Great. So our first element then is the well-founded fear. I like to think of this as the element that encompasses all of the other elements, right? It gives you both your burden of proof and it tells you how the other elements have to be demonstrated and how they interact with one another to get to that ultimate goal of showing that your client has a well-founded fear of persecution. So the first thing is the burden of proof. For asylum, you are required to show that your client has a reasonable possibility of persecution, meaning they have at least a 1 in 10 chance of persecution. And there is two, with a big asterisk, there's 2 ways to establish a well-founded fear of persecution. Again, this essentially dictates how all of the other elements have to interact with one another. And the first way is to show that there is past harm or past persecution, and that meets all of the other elements of asylum. And the other way is to show that even though there is no past persecution, there is a reasonable possibility of future persecution that meets all of the elements of asylum. Whenever possible, you should argue for both of these different ways of establishing belief, right? Even if one is much weaker than the other. And then as to, the big asterisk, there is technically a third way of establishing a well-founded fear. I will say that statutorily, showing a well-founded fear of persecution inherently requires that there's an ongoing threat. Now, there is an exception, a case law-based exception for this well-founded fear element where courts have held that in cases where the past harm is so severe, folks should qualify for what is called a humanitarian asylum, even if there is no ongoing threat. So that is sort of actually an exception to the well-founded fear element rather than another way of demonstrating it. I will say the level of harm that is required to qualify for humanitarian asylum is very, very high, and we don't see it play out very often. But if you have a case where the ongoing threat of persecution is particularly hard to establish, then of course you may want to start thinking about arguing for humanitarian asylum. And with that, we'll go to our next slide. Great. So again, this is how do you establish a well-founded fear based on past persecution? So you have to have past persecution, which, as we'll see in a little bit, persecution really comes down to the severity of the harm, right? And then plus all of the other elements. So the persecution has to be on account of a protected ground by the government or by someone the government is unable or unwilling to control. And if you meet all of those elements, then there is a presumption that because someone was already persecuted, meeting all of those elements, someone was already persecuted on account of a protected ground and that the government is unable or unwilling to protect them, there is a presumption that the same thing will happen in the future. That presumption may be rebutted by the government, either by showing changed circumstances, which they will try to show through country conditions evidence, or by showing that it's safe and reasonable to internally relocate to another part of the home country. Now, internal relocation is particularly important where your client may have a fear or past harm that only is based on one single person. And of course, that single person may not be able to find them in other parts of the country. I will say that for our LGBT clients, generally, our argument is that because there's deeply seated homophobia or transphobia throughout the country, relocation is not possible, even if the past persecutor was only one person, right? That they're likely to suffer similar harm regardless of where they are in the country. So if we go to the next slide then. This is the other way to show well-founded fear, and that's based on the fear of future persecution, right? This has two elements. One is that the fear be subjectively genuine. This comes down to credibility, and in part 2 of the training, we're going to talk a lot more about credibility. But we did want to flag here that your client's credibility is required to be able to qualify for asylum. You'll see, and not in this training, but you'll see in other types of relief, like protection under the Convention Against Torture, that even if your client's not credible, they may qualify for relief. That's not the case for asylum. And then the other prong of this element then is that the fear be objectively reasonable. Objectively reasonable really comes down to what is the corroborating evidence, right? So if you meet those two elements, and again, those two elements have to be demonstrated throughout all of the sub-elements, right? It's objectively reasonable for your client to fear persecution on account of a protected ground, and that the government is not able or willing to protect them. And you can show that relocation is not reasonable or safe, then you will have met the well-founded fear of future persecution. One thing to note here, unlike the well-founded fear based on past persecution, here you have the burden to disprove internal relocation. Whereas if you're able to show past persecution, then the government is the party that has that burden. Okay, and we can go to the next slide. Great, so we got to our first poll. Again, please take a second to read over the case examples, the exact same examples I went over a little bit ago. They're also available as a handout if you want to pull those up and it's easier for you. But we can go to our second poll of the day. So how do you think Aminatu can establish a well-founded fear? Does she have past persecution? Does she only have a future fear, or could she argue both? All right, yeah, so this is a little bit of a softball, but that's right. Anytime that you can, you should argue both. But of course, as to her, she did have, she did have some threats from the police. She did have a brief detention. You could argue that that is past persecution, but of course, given everything that's happening in the country, I would agree that the future fear is probably the stronger claim here. So I think everyone was a little bit right on this one. And we can go to our next slide. Okay, so now we're on to our second element, the persecution element. And like I mentioned before, the definition of persecution really comes down to how severe the harm was and whether you meet that severity threshold to meet the persecution definition. There's generally two ways to establish persecution. One is significant physical force, significant physical harm. The other one is non-physical harm that, again, meets that severity threshold. One thing to note, when harm occurs to someone as a child, the severity of the harm can be less. Lesser harm meets the definition of persecution, because, of course, you know, harm to children it just has more severe consequences, right, to the development of a person. And then lastly, persecution must be considered cumulatively. And we're going to talk a little bit more about that in the next slide or so. But one thing to note is, yes, we are trying to meet that threshold of severity. But when we are trying to meet that threshold, it's important for us to look at the full picture of what all our client has gone through. So if we go to our next slide, here we have a few common forms of persecution in LGBT cases. Of course, physical violence, as I mentioned before. I will note, as far as persecution, this is a very fact-specific element. So the first thing you should do is look at the case law in your circuit and see what the court in that circuit has said about persecution, right? If you have a client with who has suffered physical violence, definitely go look into that. Some courts have really good case law, other courts not so much. But really, the ideal thing would be for you to find some sort of analogous case, right? Where it's like, my client was beaten 5 times by the police, and then if you happen to find a case that has a very similar fact pattern, that's definitely what would be ideal. If not, of course, we want to analogize as much as we can. When it comes to beatings, even one beating can be sufficient, but it comes down to, again, severity, right? Was medical help required? Did it leave any lasting injuries, and so on and so forth? And then we have other forms of persecution, rape, credible and serious threats. Now this goes back to the Aminatou example, right? Credible and serious threats may rise to persecution, but only when there is an immediate threat and there is some attempt from the persecutor to actually follow through with that threat. And then we have forced marriage and conversion therapy. Also, we see those often. So if we go to the next slide, we have additional forms of past persecution. And again, here's where we try to look at the full context and the full experience of our clients to meet that threshold of severity. Two arguments that are sort of the same, right? Just framed a little bit distinctly, are their inability to live openly and pervasive discrimination and extreme harassment, right? Meaning, even if they don't have any one incident that rises to persecution solely, the fact that they had to endure day in and day out discrimination and harassment, economic deprivation, and of course, as a result of all of those acts, were unable or felt unable to live openly, then we would argue that in the cumulative is also persecution, that arises to persecution. These are, I will flag that these are not as well established in the case law, but they are arguments that we at NIJC try to make as much as we can, and that we think are important to push through. So we can go to the next slide then. Great, so we have another poll. And hopefully you already have the handout pulled out, so we can just go to the poll. Okay, so which of the types of harm described in the case examples is most likely to rise to persecution? And we'll give it a few seconds. All right, so we had quite a split audience here. I will say that the beatings as a child that Reina suffered are the most likely to be standing alone, found to be persecution, and that's for a couple of reasons. One, the fact that they happen repeatedly almost every day, and also because she was a child when they happened. Again, threats by police, definitely something we want to look into as we're assessing the past harm that our clients have suffered. But like I said, the threats have to be both immediate and there has to be some attempt to follow through. So those are very fact specific and not as, definitely a good argument for Emma not to, but not as clear cut as the beatings that Reina faced. All right. Then we can go to our next slide. Great. And so we're on to our third element. And broadly, to qualify for asylum, you have to show some sort of government involvement, right? Whether the government itself was the persecutor or whether the government is unable or unwilling to protect you. You have to show one of these two. Now, when is the government the persecutor? Obviously, right, the police, the military, security forces are government actors. But of course, but also teachers in public schools, right, may be government actors. Doctors in government-run hospitals may be government actors. In some countries, there are arguments to be said about the fact that gangs act as de facto government, where the government has very little, has lost control over the country essentially. Those are tougher arguments to make, but if you think that is the case in one of your cases, for sure, bring it up to your NIJC contact and we can look into that sort of argument a little bit more. And then who are essentially anyone who's not a government actor, but who the government should be able to or willing to control, also qualifies as a persecutor, right? Whether it's gangs, whether it's family members, whether it's, I like to think of this as just the general public, right? And how the government reacts to that segment of the public. So then we can go to the next slide. Great, and I think we're back to Lee now. So I'll pass it over to them.
Yes, thank you, Tanya. So we are going to move right along into our next element here. So this is the on account of a protected ground, otherwise known as nexus. So nexus is that legal term of art that talks about the connection between the persecution and the protected ground. So as you can see in our bright yellow star, it is really important that we do keep these three elements separate. So we're going to talk about one of those protected grounds in a minute in more depth, but you can see here that, race is read as broadly. So someone's race can include, perhaps a different ethnic group. Then religion, sometimes a little bit more straightforward. Nationality, again, it's not just citizenship, but could also include ethnic or linguistic groups. There's some overlap here between nationality and race. And then political opinion, which we have listed down on the bottom here. Again, it can be actual or imputed. So your actual opinion or something that, an opinion that is imputed on you or people assume it would be. So maybe a child of a political activist, their political opinion is imputed to be the same as their parent, perhaps. And so the last one, the membership in the particular social group, we'll go through in a minute because it's one of the more common ones, especially for our LGBT cases. And it's also, unfortunately, one of the more complex ones. So with nexus, again, we have the persecution, and Tanya spoke about the different types of persecution, but then we need to show that they were persecuted because of a protected ground. So on account of their protected ground, that is why they were persecuted. Okay, next slide, please. So here we see some case law that talks about the burden of proof for nexus. this is another area where there is continuously changing case law. So keep in touch with your NIJC contact, keep referring to practice manuals that we'll have up that will talk more and more about nexus. Generally, we're looking at one central reason. So, you know, in the second bullet, persecutor can have mixed motives. There can be a couple of reasons why that persecutor targeted and harmed this individual. But again, the protected ground, one of those 5 protected grounds, needs to be at least one central reason. So how do we prove this? How the heck do we show that? Stay tuned for part 2, because we're definitely going to go more into how you actually would prepare a case and evidence this nexus element. But generally, you can use circumstantial evidence. So, you know, the types of words they use, what was going on in the whole context of the harm that was happening to this person. Okay, next slide, please. So we are going to take yet another poll. Again, these are in the handout, the hypos, the case descriptions are in the handout. So what is the nexus for Amanatu's harm? What protected ground do you think best connects to on the account of element? Why was she persecuted, in other words? Okay, we have about a third of everyone voted, so I'll give you a couple more seconds. Okay, so sexual orientation, political opinion, or both. Okay, thank you, everyone. So as you can see, we're all a little bit right, but I think that we would go with both. So again, like when we spoke about the different types of protection, you argue the most possibilities that you can. So she would have nexus to both grounds, because, you know, a political opinion could be, you know, a human rights activist, someone protesting against the government. So that aspect certainly could connect the harm at protest to the political opinion. And of course, also the sexual orientation aspect is definitely there. Again, there can be multiple central reasons for the harm. You just have to show that for each protected ground you're arguing, there's a central reason. Even though we don't have a poll for it, we'll talk about Raina for a second too. So we can show a nexus between the LGBT identity and the harm, especially the beatings, because of her gender presentation. Here, nexus will definitely be a little trickier because, as our facts show, her other siblings were beaten as well. But we need to show, using that circumstantial evidence, that maybe she was beaten more frequently, beaten in different ways. Maybe slurs were used or other disparaging comments when she was beaten. So the acting like a girl comment. So nexus can be a little bit more tricky, especially, but that's definitely still something that we would argue. So there's a ton more that we could say here, just trying to wet your whistles, giving you some examples here. Next slide, please. So I've been teasing you with this for a while, but particular social group, really, like, what does that mean? So it's one of the 5 protected grounds, right? We had race and nationality, we had political opinion, religion, but this 5th one, the particular social group, so we have some definition words up there based on a common immutable characteristic that members of the group either can't change or should not be required to change. And you can see that comes from the BIA case law. So we focus on this one and not the other 4 because, especially in the LGBT cases, it's the most common. So this is yet another term of art where the definition is really in flux and other courts have interpreted it very differently. So for those of us on the training who are lucky enough to be in the 7th Circuit case, so we can see the difference between the BIA's interpretation and the 7th Circuit interpretation. We see that there's a difference between the ways that in other circuits, perhaps you might need to argue that the group is not too broad and that it is distinct in society or visible in society or there might be too many people or not enough people in that group. You can see that there is a link here to the particular social group practice advisory. So that is definitely helpful. Again, in the Seventh Circuit, we really only consider the immutability. So is it something that they can't or shouldn't have to change? We can go to the next slide. Great. So here are some of the common particular social groups that we have established and can put forward in our LGBT cases. There is really pretty decent case law establishing an LGBT particular social group, but again, everyone is going to have a slightly different way of defining their group. And the extra point with that is that, like many places in the law, the case law is behind. It is, more conservative, less inclusive than the lived reality of our clients. So, especially if we jump down towards the middle of this slide, in the case law, transgender gender identity has been framed as gay men with female sexual identities, which does not reflect lived experiences of our clients and is not the terminology that we use when talking about our clients and that our clients use when talking about themselves. So again, we will use the case law when it's helpful, but also really kind of move the ball forward in having the way that the particular social group is defined be able to truly reflect the person's identity. So basically, when we're talking about sexual orientation, that's really not very controversial. Since 1990, being a lesbian woman or a gay man has been recognized. And then, like I just mentioned, in the gender identity context, sometimes there's some reframing that we have to use here. So, for example, the particular social group might be defined as a transgender woman or a gender nonconforming individual. So a transgender woman from Honduras might be one example. And this is definitely somewhere where NIJC can help provide some technical assistance. And just as an aside, especially here in Chicago, we've seen both immigration judges and the asylum office be really respectful using a person's name and pronouns, because it might be your client might not have been able to change their legal name. So their legal name may not be the name that they're currently using. So you keep that in mind, and always, like Becca mentioned earlier, treat your client, present your client to the adjudicator with respect. So moving slightly differently with HIV status, standalone HIV status is a little bit more difficult, but there are times where it has been kind of recognized as the particular social group. But we often also will simultaneously argue an imputed sexual orientation. So remember when I said that the political opinion can be imputed? This is also true for a particular social group. That can also be imputed. So someone might be a gay man, or someone might have an imputed sexual orientation where their society, their people will think that they're a gay man, even if they may not personally hold that identity. We often see that kind of commingled with an HIV positive status, because in some places, HIV positivity may have this assumption of a gay sexual orientation as well. So kind of keep all of that in mind. With a case example that we see here is one of our cases, Velázquez Vanegas, where the court recognized that there is that association between HIV status and being a member of the LGBTQ community in Honduras. So based on that, because Mr. Velázquez is HIV positive, then others will perceive him as gay. And so then he would be at risk of serious violence because of that perception. Okay, we can go to the next slide. So there's not a poll on this one, so you can relax back a bit, but just looking at these examples on how we could define that particular social group. So for Aminatu, she has a little bit more of a straightforward particular social group, right? Think about it to yourself. How would you define it? I would probably define it just simply lesbian women from Guinea. And that would be her PSG. But also remember that she, like we talked about a little bit earlier, she also has another protected ground, the political opinion ground. So you would argue both. Then moving on to Reina, her particular social group might be a little bit more complicated. She has some overlapping particular social groups based on her real identity as a trans woman, but also based on how she likely was perceived. She might have been perceived as gender nonconforming. As a child, she might have been perceived as, generally a member of the LGBTQ community. And again, keeping in mind, there are quite a few places that this distinction between sexual orientation and gender identity is not salient, it is not recognized. And the types of terminology that people might use to self-identify their sexual orientation and gender identity may not be similar to the terminology that we would use in the US. So there could be a particular social group of transgender women from Honduras or gender nonconforming individuals from Honduras. So again, we could go on and on about some of these examples, just a little bit of an idea, a little bit teasing out to start. Okay, next slide, please. Okay, so again, how do we prove this? This is we're going to really go a lot more into detail in part 2, but to give a bit of an overview for today, for sexual orientation, the biggest, most important type of evidence and proof will be your client and the credibility of your client. So again, make sure to join us for part 2 to get some tips and tricks in obtaining credible, detailed, and consistent testimony from your client. Other types of evidence, third-party affidavits, friends, family, current or past partners, medical providers, psychologists, all these types of individuals can write affidavits or letters of support to corroborate or to back up your client's sexual orientation. So then, any proof of activism, any types of, I once had a client that hosted a gay karaoke night. So I submitted a poster of his gay karaoke night as proving membership in the social group of gay men. And then just one point here, there's a difference between conduct and identity. So your client might identify as gay even if he has never had a boyfriend before. So that, again, separating out the conduct of having those relationships and the identity, though it's still a viable case if your client hasn't had a boyfriend but still identifies as gay. It just sometimes is a matter of being a little bit more creative with the evidence that you get. But on the flip side of that, there are plenty of people who might engage in same-sex sexual conduct, but who don't identify as gay or wouldn't have that identity term that one might assume. It could be, then that could be an imputed claim. There could be other ways to try to work around both of those instances. And then one extra note about this, don't allow the government or the court or the adjudicator to focus on sexual activity. That's inappropriate. We've had good luck here in Chicago that adjudicators do not and don't ask inappropriate and probing questions, but that's just something to keep in mind. A quick note about bisexuality and pansexuality and queer identity, some of those other types of more umbrella terms that Beck spoke about earlier. those are definitely viable claims. So it's really just a matter of getting enough detail, enough testimony, enough corroboration, and just reminding the adjudicator that yes, bisexuality is a sexual orientation and it is a protected group. So if you do have such a claim, check out some of those cases. So Fuller was a bisexual man from Jamaica that was initially denied, but then so that was a negative case, but that has a good dissent. But Lynch was decided a little bit differently. So again, delve into the case law here. So then kind of switching gears a bit to proving membership in a particular social group that's based on gender identity. One option here is to show evidence of a social or medical gender transition. So again, any sort of gender transition is not required to identify as transgender. Many transgender people don't pursue a medical transition. So, but some people do. Everyone who is trans will have their own way of talking about their gender identity and different steps that they've taken. So again, things like that can involve in different clothing that someone might use, a different gender expression that someone might use, legal documents being changed, name change, gender marker changes. Those are some things that you can use to show kind of evidence of someone's gender identity. Okay, and then down to the last one of HIV status. So, you can just kind of show the medical evidence there. The next thing that we're going to talk about is this thing called the 1-year filing deadline. Not to get too far ahead of myself, but if that's at issue, then you might need to show some medical documents that have dates on them, when someone learned of their status, when someone was diagnosed. And then with that imputed sexual orientation based on HIV status, then the proving the membership is a little bit different, right? We'll want to definitely have the credible testimony of the client in the form of their affidavit and their testimony at their interview or their hearing, but country conditions will be hugely important here. So country conditions evidence, again, we'll talk a ton about this on Thursday, but different governmental reports, NGO reports, news articles, things like that showing that yes, people in such a place do perceive HIV positive individuals as LGBT. Then also experts, having an expert witness who is an expert in the study of that country that can also speak about that connection, about how that is a social group. Okay, we can move on to the next slide. Okay, so the thing I just queued up, the 1-year filing deadline. So we have a little bit of a definition here. The basics is that there is this additional requirement for someone to be granted asylum, that they need to have filed their I-589, which is the application for asylum, within 1 year after the date that they arrived in the US. So if someone came to the US today on June 15th, 2021, then they would need to file their I-589 by June 14th, 2022. If they don't, then they have failed to meet their 1-year filing deadline, and based on the statute would be ineligible for asylum. However, that is not all hope is lost. So next slide, please. There are exceptions. So there are 2 main buckets of exceptions to the 1-year bar or the 1-year filing deadline, that are changed circumstances and extraordinary circumstances. So the changed circumstances, I like to think of it as there's a change in circumstance of the person or a change in circumstance of the country of origin. So, you know, coming to terms with your sexual orientation or gender identity, maybe, you know, like many folks, it takes time to really solidify how you identify, especially in many aspects, but especially with sexual orientation and gender identity. So that is one example, and related, either coming out or unfortunately being outed. So other people sharing or having been, you know, unfortunately shared without your consent information about your sexual orientation or gender identity. And maybe being diagnosed as HIV positive, or steps in medical and or social transition. Let's say you had a legal name change and now your identity documents have a name that matches your identity, but then that's a change. That is a change in circumstance that could and would affect your potential return to your country of origin. So think of things that would change the way that someone would be able to not live safely in their home country. Then moving down to the extraordinary circumstances, the first one is basically the thinking about mental health. So think about extraordinary circumstances as something that has manifested itself, that has prevented your client from filing for asylum earlier. So things like, you know, if the severe mental health got in their way and it prevented them from taking the necessary steps to solicit asylum. So then we have other options here that might make it hard for someone, even especially to disclose to an attorney what their sexual orientation or gender identity is, you know, the stigma, avoidance, isolation, or, you know, illness, that they had to really just focus on being well, and they weren't able to focus on seeking help. Then we also have ineffective assistance of counsel and inability to find a counsel, to find an attorney. One big caveat here, in either of these, if you've found an exception, that is a great first step. But the individual, your client, also needs to file for asylum within a reasonable time period of that changed or extraordinary circumstance. One more extraordinary circumstance that I didn't mention is having previous lawful status. So maybe someone's a student, they're here on an F1 visa, and then, you know, they're living here, they're realizing, yeah, I do have a fear of returning. They can file within a reasonable period of falling out of that status. So generally, we have this, not really in the law, but this kind of 6 month benchmark. So within 6 months of this changed extraordinary circumstance, falling out of status, filing soon thereafter, but definitely within 6 months. Okay, next slide, please. And we have our last poll of the day. So again, we have the case examples in front of you. They are also a handout. So which one of our 2 potential cases is likely to present a 1-year filing deadline issue? So Amanatu, Reina, or both? So again, who as a potential client will you need to think about? Have they missed their 1-year filing deadline? Will I need to look for an exception? Okay, we have about half of our participants who have voted, so we'll give you a couple more seconds to get your votes in. Okay, thank you. So we have the majority of us voted for Reina, and you know, we're right. I guess the trick answer might be you have to think about it for both, because for any asylum case, you'll need to meet the 1-year filing deadline or an exception to the 1-year filing deadline. But Amanatu, what is great about her case is that she has recently entered the United States. So she's still within that time period. Just if you're her attorney, you'll need to make sure that you do file her asylum application before that 1 year passes. For Raina, then we'll look more into those exceptions. So for her, we'll probably focus on her transition. So the steps that she might have taken recently. So in our facts, we say Raina began her transition a few months ago. So if you were her lawyer, you would get some more details there. What steps has she taken? Who has she come out to? Has she taken other social or medical steps in transition? Can you find evidence that would point to a time or a place in time that you could base that, oh, here is where there is a change of circumstance that makes it more dangerous for her to return. Okay, we can move along to the next slide. Thank you. So before we wrap up for the day, we just have a couple of other considerations to talk about. Next slide, please. So then there are things there's changes, especially in the ways that we've been seeing the adjudication of cases. There's a ton of delays, both in court and at the asylum office. Life happens in the meantime. So there are things that might happen that might make your client eligible for other relief. Let's say she gets married, or unfortunately she's a victim of crime. She might be eligible for a family petition, for a U visa, but be checking in with your client frequently, because they should not be filing any other applications without you knowing, and preferably without you representing them for that. But like it says in the bottom, check in with us right away if there are any changes, because there are some changes that might compromise her eligibility for asylum. Travel. So under only the most emergency of circumstances, asylum applicants, if they leave the country, they will abandon their asylum application. If they return to their country of origin, that would very likely affect their future ability to seek protective relief. I'm not even going to talk much about the ability for advanced parole, because we just see it very, very rarely. And then some marriages might compromise eligibility. If your client identifies as a gay man and then marries a woman, then that could compromise his ability to credibly show his membership in a particular social group of gay men. But of course, every person is different and every situation is different. So nothing here is automatic, but keep a lookout for those things too. And if your client has been arrested, charged with a crime, convicted of a crime, there are quite a few criminal bars to both asylum and also to withholding of removal. So try to keep as close of contact with your client, and as soon as you may hear of a client's arrest, again, be in touch with us, because again, some of those types of convictions can bar asylum relief, but even unconvicted crimes, both here and in countries of origin, do affect eligibility for asylum and also for withholding of removal. And then of course, changes in the law. Law happens, so as much as you can, keep your eye out for practice advisories that NIJC publishes, and of course, with any questions, come back to us. We develop practice manuals on the big changes in law very, very frequently. Okay, next slide. And we are back to you, Anisha.
Hi all, thank you for joining us today. I hope that you learned something, and I hope that you'll come to part 2 on Thursday, this Thursday. And if you have any questions, if you're interested in the case, an LGBT case specifically, you can reach out to me. My email address is right there. And we would love to hear from you about the training. So if you could do, if you could put up you can do the survey by putting up your phone to that QR code. And it should take you right to the website where you can finish the survey. And we will also be sending out the CLE credits, the certificate with the credit information. So please look out for that. And again, if for whatever reason you don't receive it, feel free to email me and ask about it. We didn't have any questions to go over today, so we're going to end a bit early. But again, feel free to reach out, and we look forward to seeing you on Thursday.